Hi, Steve Hansen with Hansen IP Law. Hey, I want to talk to you today about something that a lot of people who are new to the patent system get tripped up on, and that is, how do you determine if your patent is infringed? If somebody's violating the patent and you can take them to court and sue them for patent infringement. A patent has a number of different sections. It's got a section called the specification, it's got a section called the drawings, it's got a section called the claims. And people who are new to the patent system sometimes will compare their drawings to what their competitor is doing, or they will compare sort of what they think the gist of their invention is to what their competitor is doing. But that's not the test. There's a very specific test in patent law for determining if a patent is infringed, and that is that each element of at least one claim must be found in the accused product. Okay, the accused product is what the competitor is making. That's the term that we use, accused product, because you're accusing it of infringement. And the test is, does that product have in it every element of at least one claim in the patent? If it does, then it's infringing. Now, an element can be present literally or something under the doctrine of equivalence. We're not going to deal with that in this video. We're going to deal with that at a later time. But basically, the test is, do they practice every element that's in at least one claim? Now, to help you out, I'm going to show you a recently issued patent. This isn't one I worked on. It's just one I got off the Patent Office database. It was issued on July 4th of this year. It's called Bandage with Microneedles for Antimicrobial Delivery and Fluid Absorption from a Wound. And what we're going to do is we're going to look at the claims, which are in column 4 of this patent, and they begin about line 23, where it says, what is claimed is. The text that follows the phrase, what is claimed is the claims. And you can see here that on this page, and I haven't shown you the next page of the patent, on this page there are 5 claims, and then, well, actually 6 claims on this page, and then I think there's a couple on the other page. So we have to look at these claims, and if at least one of them has each one of its elements present in the accused product, then it is infringed. Now, claim 1 here is an independent claim because it doesn't refer back to another earlier claim, so it stands on its own. The later claims are dependent claims, and a dependent claim by definition includes all of the features listed next to it, plus the features in the claim to which it refers. So in other words, claim 2 requires everything that's listed in claim 2 plus what was listed above in claim 1. Now, I'm not going to use this patent to illustrate how to look at patent infringement because it's a little complicated and I don't have a good example. So what I'm going to do is I'm going to show you a very simple example. This is not a real patent. You could not get a patent on this right now. But if this patent did exist, this is the analysis that you would use. I'm going to pretend that there's a patent on a 3-legged stool. Okay? And so what I have here is a claim that you might have in that kind of patent. And it reads, a stool comprising a disc-shaped seat having a radial direction and an axial direction, and an upper surface and a lower surface spaced apart from one another along the axial direction. And it also has a plurality of legs, wherein each leg in the plurality of legs is attached to the lower surface of the seat and spaced apart from the other legs in the plurality of legs, and each leg in the plurality of legs projects away from the seat along the axial direction. Okay, so in order for an accused stool to infringe this claim, it has to do everything that's listed there. Now, it could have other things, it can have additional things and still infringe the claim. The key is it can't have less than what is listed in the claim. So this claim basically requires a disc-shaped seat and 3 legs. And they have to be on the bottom of the stool, and they have to project away along what we would call the axial direction. So if you look on the chart, I've mapped out where the claim elements are found in this particular stool. This is called a claim chart. If you're ever in a patent lawsuit, this is a type of format that's typically used to demonstrate infringement. But in the first row, I've circled the seat, and that's next to this disc-shaped seat element. You can see in this case that the seat is shaped like a disc, and because it's a disc and it's circular, It has a radial direction, and I've shown where that is on the chart. And then the direction perpendicular to that, of course, is the axial direction. So we can see here that the first element of the claim, the disc-shaped seat having a radial direction and an axial direction, as well as an upper surface and a lower surface spaced apart from one another along the axial direction, is met. All that's there because the disc has a thickness, basically. So we got to the next element, which is the plurality of legs. So this element requires that the legs be attached to the bottom of the disc-shaped seat, which we can see that they are, and that they are spaced apart from one another. We can see that they are. They're all separate. They attach at the bottom of the seat at different points, and they all have a length where they project away from the seat along the axial direction. And basically what we're saying there is that the legs stick out along the thickness direction of the seat. And so here, every element of this claim is met by this stool. So this stool would infringe this claim, and you would have a valid claim of patent infringement that you could pursue, and on which you could go to court and seek an injunction or at least monetary damages. So it's very important to remember that this is the analysis that you want to do when you're looking at whether a patent claim is infringed. Now, I'm not saying that as lay people you should run out and do your own infringement analyses. There's some sophistication to it. As I mentioned earlier, there's a thing called the doctrine of equivalence. There's rules about how claim terms are supposed to be construed. There are a number of things that you would want an attorney's help with to make sure that you're doing this accurately. But if you want to sort of take a first cut at it to see if you're in the ballpark, if your patent is potentially infringed, this is what you do. You look for at least one claim and make sure all of its elements are present in the product that you hope to accuse of infringement. And then, you may have a shot at a case, and you can take it to your attorney and do a more detailed analysis and deep dive from there. Okay? So anyway, that's it for now. See you next time. I'm Steve Hansen with Hansen IP Law.